Think you've reached a settlement agreement? Maybe you didn't. In an ideal world, separating and divorcing couples would all be able to reach a settlement on all the legal disputes arising from the resolution of various legal issues. This would save time and expense and money and avoid their having to go to court. Sadly, this tends to be the exception rather than the rule. Where former spouses are unable to agree on at least some of the issues, where they're able to agree on at least some of the issues and reach a settlement agreement, or what the lawyers call minutes of settlement, they may not be as successful at reaching a consensus as they think. It may become evident only after the fact that they do not agree on how to interpret and apply the agreement's terms. This can even happen when an agreement is reached that purported settlement with the help of separate lawyers and after extensive negotiation. In a recent case, parents thought they had reached a settlement agreement, and it was formalized into a final order of the court. However, the parents later disagreed on how the agreement was to be applied and interpreted in their everyday life. Although the specifics of the couple's dispute were unremarkable, it gave the Ontario court an opportunity to set out some of the guiding principles that inform the exercise of trying to interpret a separation agreement that is formally embodied into a consent order of the court. Borrowing from two leading Supreme Court of Canada cases, this decision on general principles of contractual interpretation, the court noted the following: a consent order is simply a species of a contract. It is often to be interpreted by reading its provisions as a whole, giving the words their ordinary grammatical meaning in a manner consistent with the surrounding circumstances known to the parties at the time the order was made. It is not governed by subjective views of the parties after the fact. Instead, the court must interpret by looking at its language, the circumstances in which it was granted, and the pleadings in the litigation. The court added that contractual interpretation is not a mechanical task. It involves more than simply reading the words that the parties used and giving them their plain and ordinary meaning. Plus, in situations where the contract is ambiguous, it involves looking at the circumstances surrounding the factual matrix that the parties were aware of at the time they entered into the agreement and it was signed. The question of what amounts to surrounding circumstances will vary from case to case. We're going to look at that in a future blog and take a look at how these principles are applied to real-life settlement agreements and consent orders, where the spouses thought they had reached a negotiated deal with one another, but were sadly mistaken. Thank you for watching. You can hit the little bell at the bottom to subscribe. You can like and share this video with your friends. There'll be a comment box at the bottom of this video. You can leave any comments or questions that you have, and we're going to endeavor to answer those questions at the end of each week. I'm Russell Alexander.